Exploding pagers and other radio communication devices in Lebanon this week killed dozens of people, presumed to be members of the militant Islamist organization Hezbollah, and injured almost 3,000. Although Israel has not acknowledged that it was behind the attacks, it is generally assumed to be responsible. There has been an intense discussion about whether the use of such electronic devices as weapons is legal, based on international rules of war. And here in Germany, there is further debate about whether this country should continue to be one of the major suppliers of weapons to Israel. To talk about these issues, we are joined by Alexander Schwarz, an expert on international law. He is Deputy Director of the Programme on International Crimes and Accountability at the European Centre for Constitutional Human Rights here in Berlin. He joins us today from the city of Leipzig. Welcome, Mr. Schwarz.
Welcome.
So let's start in Lebanon. Thousands of devices exploding simultaneously with no control of where they are at the moment of the explosion, who is in the vicinity, who will be hit. Is that a tactic of war that is allowed in international rules, or is it an act of terror?
Well, the attack on pagers and radios to be legal need to fulfill at least three requirements. They needed to distinguish between civilians and fighters, they needed to be proportionate, and they needed to be militarily necessary. The problem is that every civil explosion had to comply with these principles. And since Hezbollah forms part of the government and is ultimately integrated into the Lebanese state system, it can be assumed that there is international armed conflict between Lebanon and Israel, so that Hezbollah fighters are a legitimate target. But while some of the attacks on pagers may have met these requirements, there is reason to believe that in many cases this won't be the case. And to meet its obligations, the attacker, possibly Israel, would need to have checked each individual communications device to make sure its detonation targeted a combatant and not a civilian, for example, mistakenly holding the object or standing too close. And I think here's the problem, because it rather seems like that individual checks of the legal requirements were not made, given that thousands of pagers and walkie-talkies exploded simultaneously. And it would be concerning if there was no observation to ensure that civilians did not have the pagers on them when they were detonated.
Well, but at the same time, you have to say, presuming that Israel was behind these explosions, and we are all assuming that, it's at war with Hezbollah. There have been hundreds of exchanges of fire recently, dozens of casualties on both sides. So it's war. Doesn't that justify pretty much any form of attack?
So as I said, the attacker always has to make sure that it bears some control of the attack itself, and that the attack is done in accordance to international law, especially international humanitarian law. So even assume that most of the pagers were actually carried by Hezbollah fighters, which would be legitimate in international law, it is more than questionable whether they were proportional, because each explosion would have been has been committed at the same time. And there's the problem, because in addition, the attacker, possibly Israel, has to comply with the principle of precaution, which requires that the attacker takes all the measure to make sure to minimize the risk of civilians to be affected by the attack. And it seems at least that concern to some of these incidents, it wasn't really observed.
But you might be able to say that, clearly some of the casualties, or maybe many of the casualties, maybe even the majority of the casualties, were people very closely connected to Hezbollah. There are reports of some senior members having been hit, including the Iranian ambassador. So you might say, well, how shall I say, the collateral damage done, the damage done to civilians and so on, people that were not targets, weighs up the or is outweighed by the fact that so many real targets were hit.
Yes, exactly. When it was made sure that the attack attacks really were targeted at legitimate targets like Hezbollah fighters, there is no violation to international law. But it has to be distinguished between civilians and fighters. And the question of collateral damage is linked to the question of proportionality. So to make an extreme example, if, for example, an Hezbollah fighter at the time when the explosion took place visited a kindergarten and was surrounded by children, here again, it's the obligation of the attacker to make sure that this concrete incident is in accordance with proportionality and is precautious to minimize the civilian harm.
So basically you're saying this kind of attack is not necessarily illegal, as it were, but the control that was exercised was much too small, much too reduced?
I think there's still some information lacking. So what we know so far, there are civilians under the victims, which speaks in favor that while some of the attacks may have met the international law requirements, there are many cases where this was not the case, and this needs to be proven. So therefore, we have to wait until we have much more information on details that are really mature enough to have concrete evidence to assess the question legally and ultimately.
So in terms of international justice, if somebody who was injured in these attacks or the family of somebody was killed, would they have any possibility of engaging in legal action against the perpetrators of such an attack, for instance, against Israel?
Yes, since Lebanon has reversed the move to authorize the International Criminal Court to investigate alleged war crimes on its soil, it would be possible that Lebanon could try to activate the International Criminal Court to investigate those crimes on its territory.
Germany has been one of the major supporters of Israel for many decades, and maybe one could say even more so in the last year or so, since this attack by Hamas on Israel almost a year ago, in which over 1,000 people were killed and hundreds abducted. But that support is increasingly being questioned, that support of Germany for Israel, including, I think, by your organization. Why is that?
Well, nearly 1 year since the October 7 massacre of Israeli civilians, the war grinds on. The people of Gaza are starving and displaced with nowhere safe to go. Dozens of documents of UN bodies and international organizations show that serious violations of international humanitarian law and even war crimes are being committed in Gaza on a large scale. Meanwhile, more than 40,000 people have been killed in Gaza, over 60% of them women and children, so the majority of the victims are civilians. And when it comes to arms export from Germany to Israel, for example, our position is that as long there is a clear risk that weapons that Germany exports to Israel are being used to commit war crimes against civilians in Gaza, Germany is obliged to stop supplying weapons to Israel, and any other kind of actions would be in violation of international law.
But surely Israel is allowed to defend itself.
There is not a question of self-defense. The question of self-defense of Israel against attacks from the outside of its territory are unchallenged, and they have to be in accordance to international humanitarian law. That means the laws of war. And as long as there's a clear risk that Israel is committing war crimes on a large scale, there is no possibility for a third state like Germany to support this and to even become complicit in committing these crimes.
Your organization, the European Center for Constitutional and Human Rights, supported some Palestinian families in 2 court cases, I think it was, here in Germany, trying to get the courts, in fact, to do what you just mentioned, to stop Germany from supplying weapons to Israel. But those cases actually were thrown out by the courts. You were not successful. What happened?
So the court so far dismissed our lawsuits because they said that our clients are no subjectively affected by the arms exports, And in one case, in the Berlin case, the court said that actually there are no pending licenses of weapons of war from Germany to Israel. At the same time, however, and I think this is important to distinguish, it must also be said that Germany seems to become more cautious with regard to weapons of war. But in Germany, there is a distinction between weapons of war and other military equipment. That was the reason why we filed a second lawsuit in Frankfurt, which was directed against this military equipment. So roughly speaking, everything that can fly and kill falls into the category of weapons of war. And since March 2024, apparently, because we have no information that can be verified, apparently licenses were only issued for other military equipment. And we have to be careful here, because the federal government still issues licenses that also include, for example, ammunition, or appears to include ammunition, including large caliber ammunition. And until July of this year, the German government also issued licenses for components explicitly for the manufacture of weapons of war. And this shows that Germany's restraint or reluctance is only apparent, and that we have no guarantee that weapons that bear the risk of war crimes being committed with them will be delivered to Israel so far.
Well, there is the example of the United Kingdom. The United Kingdom very recently stopped exporting certain categories of weapon to Israel, and the reason given was Israel's record on humanitarian international law in Gaza. Germany does not seem to have such scruples.
Yeah, the German government argues that it is complying with the law, and that the German government is not convinced that Israel is violating international law with the exported weapons. And they also argue that they regularly remind Israel to respect international law. But as we can obviously see, this is not enough and not effective, since we have more than reasonable doubts to believe that Israel is still violating international humanitarian law.
Well, the German government recently said that it has not stopped exports to Israel, even though there were some reports, as you said, that it has basically wound down such approvals. The German government has also always said that in the normal process, it does a lot of scrutiny of exports of weapons anywhere, especially into conflict areas. So the controls, the German government says, have always been in place.
Yes, this is exactly what the German government is arguing so far, and that was also accepted by German courts so far. But the problem is that the German arms export systems control system is completely intransparent. So even so far, the courts that deal with these lawsuits never really control this kind of control system by the German government. So we have no clear information how really Germany is assessing the legal questions behind these licenses. So this is something like a black hole. We don't really know how the German government is assessing these questions.
Apart from your court case, there was also a case at the, or is, I must say, at the International Court of Justice, where Nicaragua tried to get that court, that international court in The Hague, to issue a ruling that Germany should stop exporting weapons to Israel. But that also failed, didn't it?
Yeah, so the International Court of Justice has issued its opinion, and the conclusion is loud and clear that Israel is violating international law, that Israel's occupation and annexation of the Palestinian territories are unlawful, and this opinion also entailed a whole subject about third-party obligations. That means parties like Germany and other countries, that they would themselves violate international law if they would support Israel with its ongoing illegal occupation, and therefore also weapons of war exports are included. That means in the end, Germany would also violate this opinion of the International Court of Justice if it would continue to deliver weapons of war that bear the risk to be used for war crimes or other violations of international law.
But the court did not tell Germany not to do that, as it were. There was no provision by the court actually instructing Germany to stop such exports, was there?
Yeah, when it comes to the advisory opinion of the International Court of Justice of the 19th July, right, because this is a non-binding legal opinion of the court. But anyway, it entails this subject, this chapter about third-party obligations. And Germany, due to its constitution in Article 25, is in the obligation to take into consideration the legal opinions of the International Court of Justice, and by that way to comply with its opinions.
There are some experts that say this ruling on the case brought by Nicaragua may not have ended or may not have resulted in Germany being instructed not to give weapons to Israel, but at the same time the opinion means that Germany has to be more careful, that maybe Germany has to be more reluctant exporting weapons. Is that the case? Would you interpret it that way?
Exactly. I would agree to this position because in the Nicaragua case of the International Court of Justice as well, the German government argued that actually they are not licensing any weapons of war to Israel. And the court took this into consideration by saying that actually there is no clear danger that would be needed for this kind of provisional urgent actions to accept the claims by Nicaragua. But that does not mean that Germany is completely free in licensing weapons of war, because they still have to respect international law and they still have to take into consideration the violations that have been taking place in Gaza so far. So I would say yes, legally Germany so far cannot export more weapons of war to Israel. That again bear the risk of being used, because we have to distinguish between weapons that are used in Gaza, and we have to distinguish between weapons that Israel needs to defend itself, for example, from external aggressions, like aggressions from Iran. It's important to distinguish between these different kinds of weapons.
Germany has always said, at least in recent years, that the existence of Israel is something that is of central importance to Germany as a state, to Germany itself. And that is the reason why Germany's support for Israel is so unshaking, so immutable. How do you see that kind of decision in terms of international law, this kind of government decision or state decision, that the existence of that country, of Israel, is central to the German state?
I would say that this German state doctrine, this German raison d'etat, is a political concept and it's not a legal concept. And this being said, the legal concept means that it does not override Germany's legal obligations. However, this also makes it clear that the German state doctrine in defending Israel's existence cannot be used to justify violations of international law, and nor can it be used to justify support for or complicity in such crimes. I think the international rules of the law of war are largely universally applicable principles that do not tolerate any double standards, because any application of double standards undermines the credibility and thus the force of international law. And no states should participate in such an erosion of the law. In contrast, as a state governed by the rule of law, we should make sure that we are primarily committed to upholding international law, especially when it comes to the right to life, for example.
Yeah. There is another case involving Israel, or rather that case at the International Criminal Court, with the possibility of a warrant being issued to arrest Benjamin Netanyahu, the Prime Minister of Israel. There again, Germany appears to be in some kind of bind between its obligations under international law and its support for Israel. How should the German state react there, do you think?
Again, as a state governed by the rule of law and a member of the International Criminal Court, Germany is obliged to comply, for example, with the requested arrest warrants of the International Criminal Court and support the International Criminal Court in its independent and objective investigations in these crimes. I think it is even helpful for the actual situation that we have a third party, that we have an International Criminal Court that is investigating these questions independently. And what Germany did so far, for example, in the amicus brief situation, that means when they commented on the request for arrest warrants against Netanyahu and Gallant, they used further political arguments and no legal arguments. And there again, even political concepts do not have the power to override legal obligations.
Okay, I think let's leave it there. Thank you very much. That is Alexander Schwarz from the European Center for Constitutional and Human Rights here in Berlin. Thank you very much for your insights and for taking time to talk to Deutsche Welle.
Pleasure.